I'm Neil Breheny. I am a solicitor of some 40 years practice. So I've been around a while. I've been asked, and I've been delighted to present on behalf of Employment Matters, Ordmonde Solicitors, this talk on age discrimination within the workplace. Now, age discrimination is something that affects us throughout our lives. It starts when we're young and it goes on and can affect us as we get older. And as I approach a certain milestone, I'm now 64 years of age, but as I approach the old milestone, what I'll call the old milestone of 65, there are other elements of discrimination that I may come up against. Throughout the course of this talk, I may wander slightly from time to time as I relate certain anecdotes, and I hope that you don't mind. But the first one that I'd like to touch upon is an experience that I had a couple of years back when I strolled into Woody's Hardware and DIY on a certain day during the week and picked up the item that I wanted to buy, went up to the checkout desk and was given, without asking, the discount that's applicable to people over the age of 65. And I didn't know whether to be offended that I looked that age or delighted that I got it without being asked. But I didn't make much of it. I took the discount and walked away. But that's an example of how ageism applies. I wondered as I walked out, why should I, as an older member on a certain day, get a discount for that purpose? Why not a certain day of the week for other age groups? That's what came to my mind at the time. Now, what is the definition of discrimination? Basically, discrimination occurs when one person is treated less favorably than another person simply because of their age. And an obvious example that, you walk up to a well-known nightclub and you see a sign on the door saying over 25s only. Well, what's the reason for that? Or if you're in a workplace or you're going for a job and it says you need 10 years, the advertisement says 5 or 10 years post-qualification experience required for the position. That's discrimination against a person of plenty ability who may not have those years of experience. But the classic one, and one that I've been coming back to and dealing with in some depth, is one that's extremely common in context of employment, is that, or even unstated within the workplace, is that you must retire when you reach the age of 65. When does age discrimination apply? It applies all the time, everywhere. I have heard it described as pernicious. It is all pervading, consciously and unconsciously. Since we have been young children, we have been exposed to it, in many cases, not deliberately. But think of the phrases that you hear throughout the course of your life. You're over the hill, or that person's an old maid, or they've been left on the shelf. You can't teach an old dog new tricks. These are all encompassing within the lives that we live at the moment. And if we want to get past that, we must think ourselves about what way we treat people, young and old. Now, I'll offer a couple of personal observations about what I believe we need to do to get beyond age discrimination. in the first instance, everybody within the workplace has talents. They have abilities and experiences, and they each bring those characteristics to their workplace. At a simplistic level, I'm of the view that we need to, what I call mine the younger generation for their enthusiasm, their graft, their energy, their willingness to learn new skills, and the desire to develop within themselves. And at the opposite end, I think we need to mine, to put, perhaps even put pressure on our older workers within the workplace to share their experiences, their hands-on reality of what has happened to them throughout the course of their working life. They have a greater level of flexibility, dependability, and adaptability. At a very human level, the older generation that are in work now, people of my generation are around my age, we have lived through probably the single greatest upheaval in the workplace over the course of the last several centuries. I give as an example the fact that when I started my journey as a solicitor, the mobile phone didn't exist, the PC didn't exist, a modern means of communication at the time was a telex, and the fax machine, which nobody even uses nowadays, was the height of modern communication systems. We've had to live with, adapt to, and develop within all of the technologies that have come into being since the 1990s at the least. And we have survived and learned, and to a large extent thrived within it. The next generation are going to face the advent of artificial intelligence. How will that impact upon them? How will they impact upon it? And what experience can they bring to bear upon it? So there is a very much of a two-way street for young people and old people. Not old people, young people and more experienced workers to share the road and the experiences that they go down that road together. Discrimination is the one area of employment law where you actually don't need a contract of employment. In many cases, discrimination within the workplace can happen before you become employed, or should you not succeed in getting employment within a certain organization, should you apply for it. I give the example of somebody making an application for a job, seeing that it's got an age limit at the bottom or at the top end of it. Nobody over the age of 55 should apply, or nobody under the age of 25 should apply. That's unlikely to be stated, but it may very well become apparent at the job interview when you get the clear impression that the employer in this particular case is looking for an older person or a younger person, and that leads to a bias that you do or do not have, that you do not have the skill set that they're looking for, without their giving an opportunity to display that. That's ageism. That's age discrimination. It applies within the workplace itself at a number of levels. Should you be of the view that you want to advance within the workplace, but somebody else one of your work colleagues gets promoted ahead of you, when you believe that you have all of the skills, but you just happen to be younger in age, or perhaps older in age. You're in your late 50s and somebody is promoted to a position that you believe that you would be ideal for, but they've been they're only in their late 30s or early 40s, something like that. Why has the employer taken the view that you are not fit for that position, despite the fact that you would appear to have all of the characteristics that you could bring to bear on the position that's available. But the single most frequent, and it is the single most frequent area that we have been asked to advise upon within employment matters and Ordmonde Solicitors, is the time when people of a certain age are being asked, not asked, but being directed, forced to retire. You may very often come across, or we very often come across, a compulsory retirement age, generally of 65, in context of employment. And when we're asked, is that legal? The answer is, it may be, and it may not be. That is a typical lawyer's answer, but it will depend upon the circumstances. But we have frequently been of the view that it is not an appropriate area for discrimination. It is the employer has acted improperly in endeavoring to enforce that age retirement requirement. Now, I mean, within our office, the very first case that we dealt with, one of the first cases we dealt with in relation to age discrimination, is where one of our clients, who was working as a bookkeeper, had reached the age of 66, and her employer terminated her employment on the basis that she had to retire at the age of 65, or at the age of 66. But this wasn't in her contract. It hadn't been discussed with her. There was nobody else within the workplace doing the work, or set up to do the work, trained to do the work, or had been taken on in advance to do the work. She had an unblemished record. She was fit, able, and liked where she was working and wanted to continue. Now, in all honesty, it was not the most difficult case to argue. The employer's messages, texts, etc., did not do the employer any harm, and we were successful in getting a good outcome for our client in those circumstances. But I mean, and I want to make a comment and an aside here, both for employees, but directed towards employers also. The mobile phones are a godsend as far as work is concerned, but they're also a godsend for lawyers. They have given us more ammunition to pursue a case on behalf of our clients. They are brilliant for us because so much is said and done within text messages, voice messages, which are entirely inappropriate. Once it goes into that record, it stays there forever. It's almost impossible to delete it. And it's been an extremely fruitful area for us. I mean, it's also been fruitful elsewhere. If you only have to look at the what has surfaced on the phones of those people who circulate within Donald Trump's orbit, to know that what happened and what was disclosed and what was passed on their mobile phones has now come back to haunt them. From dealing with the termination or retirement, from an employer's point of view, retirement needs to be. It is not illegal to require people to retire at a specified age, provided it is in the contract of employment, and provided there is a legitimate reason for doing so. There has to be a cogent, provable reason within the workplace requiring employees to end in other words, it has to be not so much a necessity, but a developmental part of the process. And there is a workplace handbook or a guide, a very useful guide issued on age working, issued by the Workplace Relations Commission, which sets out the reasons that an employer may use to insist upon a retirement. They must be subjective and for good reason. At a practical level, the employers should point it out to employees within the contract of employment. If an employee is approaching that age, they should speak to them. Find out what their plans are. Don't leave it as a black and white, you are working today and gone tomorrow, without discussing with them. Preparation is necessary. It will lead to a better outcome for your employees and for all of your employees, and it will leave a better outcome for you as employers when you have the reasoning behind all of this enunciated. One of the main reasons why you might be able, as an employer, to require that your employees retire at the age of perhaps 65. I use 65 because that was the old, most common age within a contract of employment. And I will still use that, but I'll come back to it later on as I talk. The most common or most useful condition that an employer might place on requiring people to retire at a specified age is that they wish to have advancement prospects for younger workers within their employment, to be able to see an advancement structure within the organization so that they can move forward. That they may wish to have a balanced age workforce, so that not everybody in the workplace is of a certain age. There are advantages to having younger people, I won't say young, but younger people within the workplace and the experience that they bring to bear. So if the employer can prove that the reasons for having that term within the contract of employment are reasonable, then they may be able to mount a successful defense of a claim for unfair discrimination against a person on grounds of age. In the Atlas case, there's a well-known case, for at least for us lawyers are concerned. There was the Atlas case where the Workplace Relations Commission handed down a decision that made very much of the fact that there was no evidence presented to the adjudicator that retirement at a specific age could be justified as a reasonable aim of the organization in those circumstances. So once an employee makes a claim like this, puts forward the claim that they don't believe that there is a reasonable reason for their being required to retire, the burden of proof will shift very quickly upon the employer, from the employee to the employer, to prove that there is a reasonable ground for requiring it. I'm much and all as I am not a person to talk about statistics, but there are certain statistics that speak for themselves. The number of age discrimination claims that have come before the Workplace Relations Commission in 2022 increased by 186%. It went from a level of approximately 180 or 190 cases up to 500 cases. So that there is a realization out there amongst the workforce that they should and should not be discriminated because of their age, be that because they're too young or they're too old. And there is a willingness to take matters further. Now, what you might ask, what should we be looking for, or what are the pointers that you come across when dealing with what may be potential age discrimination? And I'm going to make the statement that it is what it is. It is very often very clear, very obvious that somebody has been discriminated against because of their age. It may be from a statement made at interview. Oh, we don't think we think you're a little bit young for that job. It may be a statement made at interview from you're going for a promotion, or that, oh, no, this is a position for a person with more experience in our workplace. These are the obvious statements, but it may be much more subtle in the employment process, that the employer is making quite obvious by the way they conduct themselves during the course of an interview that you are, in their view, not the right age for the position that they're offering. What do? You keep your notes. Keep your notes of the interview. Keep the names of the persons involved, a copy of the advertisement. If you wish to build a case, then you must put the evidence together and present that to somebody to act on your behalf. To be frank, building a case on grounds of age discrimination when it arises in the workplace, or more particularly before the employment commences, is a difficult process and requires clear evidence, not just a feeling that it is wrong. The clearer the evidence that you can present to the Workplace Relations Commission about the employment process that you have gone through that has been unsuccessful, then the greater the chance that you will be successful in prosecuting such a claim. But it needs clarity. It needs some elements of proof. Dealing with the question of age discrimination in relation to retirement matters is a far clearer process. It is much more in the employee's favor. The employee stands in a stronger position by saying, I do not wish to retire. I wish to continue. Why are you not allowing me to do so? And unless the employer can justify it on strong grounds, backed up by elements of research and evidence of the structure within the organization that supports the grounds that they're putting forward, it is very likely that a claim will be successful. There are an enormous number of people who are reaching retirement age that do not wish to go. There's a myriad of reasons for this. As we get older, this generation, they're fitter, they eat better, they work harder, and they want to continue working, not just for financial reasons, but because they're embedded within the organization that they've been working for, and they believe that they've got an enormous amount still to contribute to it. There is, in many cases, there is no cogent reason why these people should be forced to retire. And if the employer, in many cases, has sense, they won't be asking the people to retire. I mean, it's very difficult for an employer to construct a defense for compulsory retirement. It's very difficult. The cases, and speaking from the viewpoint of the acting for the employee, and that is who we have almost exclusively acted for. It has been the reasons advanced by many of the employers are full of holes. There's as many holes as there is in a colander. Almost with that exception, they've been unsuccessful. And if I might digress, it is somewhat ironic that one of the most successful defenses was actually made by a firm of solicitors when they required partners to retire at the age of 65, I think it was, and the retiring partner took on his previous partners and said he shouldn't be required to retire, and he was unsuccessful when the firm of solicitors was able to show that they had good reasons within the organization. They wished to be able to show a path of promotion for those talents within their organization that they wanted to keep. They wanted to be able to show that it was part of the regenerative process and that it was a gradual removal from stressful positions that they were asking their partners to take. And finally, it was that they didn't wish for the fee earner to face depression or feel bad about themselves when put under pressure and their fee earning potential started to decrease. So it's ironic that within a firm of solicitors, we can put together, probably more easily than lots of other organizations, the reasonable reasons for requiring our senior staff members to retire at a given age. But now, if I wish I want to take a contrarian view that not everything is as bad as it seems. When we look at the qualifications of our aging population, the educational background that they've got, the working experiences that they've gained over the course of the last 40 years, their lifestyles, their fitness, their physical athleticism, their physical fitness, their continued involvement within the community and within their organizations. I do think that they are a resource that employers are going to come back to, are going to continue to mine, are going to continue to seek out for their organizations as time goes forward. I think that, and with the change in demographics, every employee is going to become more valuable, but those of us with experience are going to last and be asked to take on more because we're capable of it. We're capable because of the lifestyles we now lead, and the medical advances and the physical advances and all the advances within healthcare and everything else that we're so aware of ourselves that we should be doing something about it, and we are doing something about it. So it is not all doom and gloom. I don't say it is doom and gloom. I do think that those of us of a certain age cohort are going to be looked upon by a large number of employers as an invaluable resource that mustn't be let go of at any cost. But that's a view that I hold, and I'm hoping that I'm proven wrong over the course of the next decade or so. Now, I'm happy to take questions if anybody wants to put them forward, but after I advertised the webinar, I did get a couple of questions that came into me over the course of the last few days. And in particular, I'm not going to give any names, but the first one is a 27-year-old person has been on to say that she'd been working within her organization in an administrative role for a number of years. She'd gone to the trouble of getting a bookkeeping qualification. And when an opening in that department within the company came up, she applied for it, but they appointed somebody in their 40s to the position. And whilst they didn't say it specifically, it was apparent to her that really they thought that she was too young for the job. And what were the steps that she could take? What occurred to me in speaking about or thinking about that question is what, from both an employee's point of view and an employer's point of view. As an employee, did she take the steps necessary to let her employer know that she'd got the extra qualification? Was she aware of what the steps were that would be required within the new position? And did she have any experience in dealing with those requirements? And if she did, then she should take the case forward. From an employer's point of view, were they aware of this person's abilities? Did she have the experience? And did they give her a fair chance to prove herself within that part of the organization? On the face of it, there is, from the young lady's point of view, there is an element of age discrimination. From an employer's point of view, the defense will be, did we know, and did she have the appropriate and necessary qualifications to do so? So it is one of those areas that falls into a very gray area. There's no, in this particular case, there's no specific answer that you can give to that question. But it's an interesting question, and one that could be pursued. A second question that I got in that, and it's much more subtle, about a person reaching a certain age, or a retirement age, or what we won't call it retirement age, but getting into their mid-60s. Over the course of the last number of years, this person has been moved to different posts within the organization, ostensibly as being a person able to do the work in this new role, but to his mind, it has been because he's getting older and his employer, with no reason, believes that he's not physically capable of doing the work. And how can he challenge that? Again, that's a difficult question to answer. The questions you ask are: is his responsibility diminished? Is his working day diminished? Does he hold less status within the workplace because of the new roles that he's taken up? And what is likely to be the final outcome within the position or positions that he's holding within the organization? If the employer, the difficulty in this case is that the employee appears to have accepted each new role as given to it, and appears to have accepted without argument the employer's reasoning behind putting him into that new role. If there is to be a challenge to it, it will require the employee to directly challenge the employer and make his unhappiness known and the reasons for that unhappiness, and to say it straight out that he believes it's an ageist approach that's been taken to it. From an employer's point of view, will the employer be able to say that this is a genuine organizational move for the person. There has been no diminishment in their responsibilities or involvement with the workforce, and it is within the norm of what they normally do, and that nobody else has taken the role previously occupied by the employee. Again, I hate to say that it's not one of those ones that's absolutely black and white, but it's definitely one worth pursuing by the employee, if only to get clarity for themselves about where they stand within the organization as they go forward. And finally, one that I've spoken to a great deal in relation to this talk. I've had a question from a person that's been within an organization for nearly 20 years, with the contract employment saying there's a compulsory retirement age of 65, which this person is coming up to. They're 63 years of age now. And this person is fit, healthy, able, would produce has told me that they would produce a doctor's examination or a certificate if necessary, and wants to stay there and believes they're able to stay there after the age of 65. What can they do about it? Well, that goes to the very nub, the core of what I spoke about earlier. What are the reasons that a person is required to retire from within the organization? If there is no clear reason for a person to retire, there's no logical reason, there's no organizational or reason for a person to move over, shall we say, to allow somebody else to step into the experiential role, to get the experience for themselves within that role, then I find it very difficult for any employer, for this employer, to be able to challenge a claim that this person is being discriminated simply because of their age. It is one of those cases where I would be moderately confident, if I knew a little bit more about the specifics of it, but moderately confident that age is definitely a reason for the person, or the only reason for the person being forced to move on, and for no other reason. Now, it's like all of these, a little bit more information is required, but I would be far more comfortable in moving forward with a case like that, and being able to speak to the client once you know a little bit more about how big the organization is, the structure of the workforce within it, the number of employees, the ages of the employees, and the categories of work that the various ages do, and what is the progression structure, excuse me, within the organization for all of its employees. But again, that's something that would be very good to look into and very interesting to look into. Now, that just about brings me, I've actually stepped over a little bit longer. I've spent a little more time on this than I had wanted to. You've seen the information about Sean Ordmonde Company Solicitors. Employment Matters is the specialist employment unit within the firm that deals with all matters in relation to employment, not just age discrimination. I hope you find that what I've spoken about is of relevance, that it gives you some little insight into what you can do if you feel that you've been discriminated against because of your age, and in particular if you believe that you're being forced out of an organization that you want to work with simply because of your age. You are not without help, you are not without resources, and you're not without the potential to seek a resolution in that regard. Thank you very much. And if you have any queries, we would be delighted to hear from you further. Cheerio.